Welcome to Business Better, a podcast designed to help businesses navigate the new normal. I'm Bill Rhodes. I'm a partner in Ballard Spahr's Public Finance Group and the leader of our firm's Education Industry Group. Today's podcast is part of our Bridging Campuses, Legal Insights in Education Industry Consolidation series, where we discuss the trends in consolidation and closures in higher education. Our goal for this series is to outline common characteristics of at-risk institutions and explore these issues, particularly legal issues, in depth across multiple topics. I'm joined today by two colleagues. Laura Giles is a partner in our Business and Transaction Department and based in our Phoenix office, and Liz Weissert, an associate in our Litigation Department and based, like me, in our Philadelphia office. Liz, do you want to introduce yourself a little bit?
Thanks so much, Bill. In the litigation department, I practice primarily in the Antitrust and Competition group. As a part of my practice, I advise clients on antitrust issues involving M&A transactions. I also advise clients on antitrust compliance and risk in contexts such as trade associations or other information or collaboration with competitors. And I represent clients in civil and criminal litigation and government investigations relating to antitrust issues.
Well, welcome, Liz, to this series. Our other guest, as I mentioned, is Laura Giles. Laura is typically co-hosting this series with me, but today she's serving as a panelist in her particular area of expertise. You want to talk a little bit about that, Laura?
Thanks, Bill, and happy to be a panelist today. As Bill mentioned earlier, I'm a partner in the Phoenix office in our Business and Transactions Department, and my practice focuses on mergers and acquisitions. And I've helped a lot of clients in the education industry work through various types of transactions, M&A transactions, and other strategic transactions as well. So excited to talk a little bit more about consolidation today.
Well, thanks, Laura, and welcome back. Today's episode is going to focus on mergers and acquisitions and antitrust and competition, as you might expect by our panelists today. So let's dive right in. Laura, I'm going to start with you. What are the financial headwinds affecting higher ed institutions as we head into 2025?
Well, unfortunately, there are a lot of financial headwinds that institutions are facing these days. And, I think the biggest and most obvious challenge that people are probably hearing about is declining enrollment. We have fewer high school graduates, which means fewer tuition dollars. And the expectation is that high school graduate numbers are going to continue to decrease. So we're really just seeing enrollment fall off a cliff. Government funding is also a real issue. We're seeing both funding cuts as well as COVID relief funding that had helped a lot of institutions, stay in business and make it through that period of time. Those dollars are now drying up. And so we're seeing a lot of results, frankly, coming to a head that maybe would have happened a few years prior, but there was extra funding available that no longer is available. On top of that, you're seeing, with inflation, a lot of operating expense increases. So, as funding is going down, expenses are going up, which makes things really difficult. And then you also just have a change, I think, in our societal view of the value proposition of higher education degrees. And, those views change over time, but I think you're seeing a bit of that. People are questioning whether a college education is going to increase their job prospects and prosperity in the future. And so, although we see ups and downs in views of higher education, I think, right now, a lot of forces are sort of culminating in difficulty for institutions overall.
And Laura, confronting these headwinds, both on the revenue side and on the expense side, we still see many colleges and universities that may be slow to react to these pressures. What do you think are some of the hurdles or the obstacles to a higher ed institution making a strategic decision to explore consolidation or closure or affiliation or other types of combinations?
Well, as you might imagine, it's a very complicated situation, of course. Just starting with the basics of complex constituencies. You have students, faculty, leadership, trustees, donors. Everyone's got a different angle, a different set of priorities, and a different focus when it comes to thinking about a transaction like this and how to grapple with the issues they're facing. So you've got a lot of different folks with different views on, what's the most important as you head into something like this.
I would think that we probably could add a couple other constituents along the same line you were thinking. One, of course, is alumni. One could be lenders and creditors. As a public finance lawyer, I would be remiss not to mention that. And also, accrediting agencies.
Absolutely. Absolutely. There are just so many different aspects of a university, and you're completely right. On top of that, and partly because of that, I think there's a reluctance to make a move, right? I think very responsibly, leadership is, having to juggle all of these different constituencies and different interests and different goals. And it takes a lot of time. It takes time to work through what's best for the institution and for students and all the other constituencies, of course. And so, it takes a lot of time. But the problem is that time also reduces your options, because what we're seeing is a lot of times institutions aren't acting quickly enough. And then things get really dire. And then their options are much more limited. And maybe now they're facing a closure instead of a consolidation. And so that is one of the biggest hurdles, is just working through all of the issues in a timely enough fashion to be able to do something really productive. And then some of the other things I think that institutions have to consider are things like cultural and academic program alignment. So, when they're looking at consolidating with another institution, for example, who's going to be the right partner for that? That's really challenging, particularly going back to all the different constituencies may have different views about that. And then, of course, and Liz is really going to dive into this, but regulatory approval, there are a myriad of approvals that institutions are going to need. And that's, another thing that's really going to affect both your timeline and your success in a transaction.
All right. And since we're really focusing on legal issues here in this series, Liz, let's pick up on Laura's last point on regulatory hurdles. How are antitrust regulations impacting this space?
So higher education has been seeing a lot more antitrust activity in recent years, including a lot of antitrust litigation. We've seen conspiracy cases based on NCAA rules, based on financial aid programs. And I advise many higher education clients about antitrust issues. And the area that's important to keep in mind is the antitrust regulations around considering a merger or consolidation or some combination of higher education institutions. And it's important to keep in mind we're releasing this podcast in early 2025, and these regulations are in flux. Things are changing in the regulating agencies, so the Department of Justice and the Federal Trade Commission. So if you're an institution that is considering some kind of combination, it will be important to keep abreast of these issues and keep updated on what the latest regulations are. So as of now, what we can tell you is that there are recent changes to the Hart-Scott-Rodino Act. You might know that as HSR. And the HSR requirements require parties to a transaction to make certain disclosures to the regulating agencies. I mentioned the Department of Justice and the FTC. And the size of transaction threshold for 2025 is $126 million. So what that means is if it's a transaction in which the acquirer will hold voting securities, non-corporate interests, or assets valued above that 126.4 million, the entities will have to report the merger or transaction to those regulating agencies. And there are a lot of requirements that go along with reporting. Just this year, a new HSR form was approved, which includes additional requirements about the competition in the markets in which the parties to the transaction compete and other information. And these changes just recently went into effect at the beginning of February. Now, coming back to my point about keeping an eye on all of this, a bill was just introduced shortly after the changes went into effect to unwind the changes to the HSR requirements. So this is something that I really encourage folks to keep an eye on. And for now, the changes have been implemented, and the HSR filing requirements, if your transaction that you're contemplating rises to that 126 million level that I mentioned, are going to take a significant amount of time, and more time than HSR filings had taken previously. So it's important to keep the antitrust regulatory requirements in mind really as soon as you start thinking about transaction or combination.
Liz, as a non-M&A lawyer, I'm vaguely aware of Hart-Scott-Rodino requirements and all that, but are they really applicable to nonprofits in the same way that we typically read about them applying to for-profit corporations?
Yes, unfortunately, the antitrust laws, including the laws requiring Hart-Scott-Rodino, do apply to not-for-profits in the same way that they apply to for-profit entities. So this is something that's relevant for a lot of institutions of higher education. Another area where we've seen a lot of antitrust enforcement in non-for-profits is in healthcare institutions. So unfortunately, this is, if the transaction meets the $126 million threshold, this is a requirement that will apply even if your institution is a not-for-profit.
And Laura, I'm going to ask you a question. In addition to Hart-Scott-Rodino and perhaps the necessary approvals through Justice or FTC, there are often state requirements. I know in Pennsylvania we have not only Attorney General review, but a local orphans court review of merger. I presume that's all state dependent.
Absolutely. Absolutely. The approvals are going to vary pretty widely and are really going to just depend on the jurisdiction and, who the various stakeholders are in each state.
So, Laura, what type of consolidations or other combinations are we seeing in the higher ed space, at least in recent years, when the number of these transactions seems to be growing consistently?
Yeah, there are a lot of different forms. One of the first that we've been seeing a lot recently are internal reorganizations. For example, the university system in Georgia went from 35 institutions to 26. So, consolidating internally to save cost. In Wisconsin, their system went from 13 two-year campuses to 7 full universities. Pennsylvania is consolidating 6 institutions into 2. We're seeing similar things in Connecticut, Louisiana. So a lot of states are looking at their state systems and how many campuses they have and seeing, how they can be more cost efficient and effective that way to help bring down overhead and see if they can't attack it from that angle. Of course, then we're seeing, true mergers and consolidations where universities, different programs are coming together, smaller private universities. I think you're seeing this most often. And, they're the ones that typically have more funding issues. They're more tuition dependent. And so they're just more vulnerable, and so we are seeing a lot more true mergers in that space. I think we're going to see a lot more things like strategic partnerships coming up. So, maybe that's an affiliation or a shared service agreement. We're seeing a lot of universities try to outsource certain functions to bring down overhead, or, of course, universities are utilizing technology more to bring up enrollment and have, an online platform. And they're doing this together, in affiliations. I would use the word joint ventures, in the M&A context. So it's sort of a version of that, but a lot more strategic partnerships and alliances. And then, unfortunately, as we talked about earlier, when institutions have waited too long, we are just seeing a lot of closures. Those have been, in the past few years, mostly 2-year institutions and for-profits. And so, the hope is that institutions can work out some sort of strategic partnership or consolidation that will be more beneficial to their students. But I think the expectation is that we will unfortunately see more closures over the next few years as the situation evolves.
So, Liz, back to some of the antitrust questions. Do the antitrust concerns change or go away depending on which structure two universities or two institutions may decide to pursue, as sort of the examples that Laura just laid out?
Yeah, I think going through the examples that Laura laid out can really demonstrate different types of antitrust concerns. And the important thing to remember here is that the antitrust laws are concerned about protecting competition. And if we're talking about consolidation, unfortunately, that is often going to lead to less competition because there are fewer competitors. But the first example that Laura gave of internal reorganizations, it seems would not raise the same antitrust concerns because it's a entity acting unilaterally. There's no consolidation between competitors or no collaboration between competitors. So I think to the extent that a university or institution of higher education can look at an internal reorganization, that might be a way to avoid some antitrust issues. However, a merger or a consolidation is going to pose potential antitrust issues. And those type of transactions, when you have two competitors who are either merging together or selling some part of one of their business to the other, is going to raise the issues with the antitrust regulators, the Department of Justice, and the Federal Trade Commission, and the Hart-Scott-Rodino disclosure requirements if the transaction is over the $126 million threshold that we discussed. And the third example that Laura brought up, I thought was very interesting, sort of shared service agreements, which Laura characterized as a joint venture. There are specific antitrust rules about joint ventures between competitors. However, they can be permissible if they're pro-competitive, if there's pro-competitive effects of these two competitors working together in a certain limited way. And so if the options would be for a competitor to theoretically cease operations entirely or to work together in a joint venture, there could be an argument that the joint venture would actually be pro-competitive. Those effects are evaluated on a case-by-case basis, looking at the markets at issue, but joint ventures do pose a particular opportunity that is different from how a merger or a transaction like that would be considered.
So even if we did something as simple as a partial affiliation, which we've seen done in the healthcare space, and still attract the attention of the FTC, and we've seen healthcare institutions that have had to scale back an affiliation arrangement that was mutually agreeable, but the FTC came in and second-guessed it and required them to reduce the level of affiliation in order for the FTC to get comfortable with it. And so I presume that that an affiliation here between two competing institutions might present the same potential risk of FTC second-guessing the terms of an affiliation. And Liz, we've seen in the healthcare space where two health systems or two hospitals have decided to affiliate, but something well short of a consolidation or a merger or a formal combination. And yet still we've seen the Federal Trade Commission come in and second guess the terms of that affiliation, and in some cases require that the affiliation terms be reduced or minimized in some ways to, I guess, be less anti-competitive in the eyes of the regulators. So I presume that if a university was thinking about dipping their toes into the waters of consolidation through, what might have started as a shared service agreement, but then maybe moved on to a more formal affiliation, they could still attract regulator scrutiny of that terms, even if it's well short of a merger.
Yes, Bill, that's right. Any collaboration between competitors could attract the attention of the antitrust regulators. So those opportunities need to be considered on a case-by-case basis, and considering aspects like the size of the market. Are these the only two schools in the area who are affiliating, or is it a large market where there are dozens of schools and that affiliation won't have a measurable effect on competition?
Yeah, and so it really could depend on how you define the market, right? And, when you're dealing often with smaller tuition-dependent universities, often their recruiting reach is in-state, for instance, or very regional in nature. And so you may be in a state where there just aren't that many colleges and universities to begin with, or you might be in a state like New York or Pennsylvania where there are many, many colleges and universities, and, market share for any one is probably relatively small. So Liz, despite our best intentions, because of the headwinds that we talked about earlier, because of the challenges or obstacles to making strategic decisions about this in a timely fashion, whether it's because you just can't find a dance partner, or you start to run out of cash, or you sort of move into a position of financial weakness that doesn't make you attractive as a consolidation candidate, and you're staring at a closure, are there any trust issues that can come up even in just a closure scenario?
So when a school, an institution is closing, they're required to set up teach-out agreements so that their students will be able to complete their programs of study. And in the process of doing that, an institution would have to communicate with its competitor institutions and come to these agreements, the teach-out agreements. And those should not pose an issue under the antitrust law. Institutions should not shy away from fulfilling their requirements to put these teach-out agreements into place. But at the same time, institutions that are considering closures should be wary of discussing details of their plans with competitors. So, for example, if an institution was considering closure and contacted some of its competitors to ask maybe what they're paying in severance to their faculty members or something like that, that could be potentially problematic if they came to an agreement about what they were going to pay in severance, just for example. So, hopefully the institutions are not at this point, but even when you're considering a closure, it is important to continue to be mindful of not communicating future plans or budgets or financial information with competitors.
Well, I want to thank you, Liz and Laura, for your time today in this next episode of this series. We would ask our listeners to be sure to visit our website, www.ballardspar.com, where you can find the latest news and guidance from our attorneys like Liz and Laura. Please subscribe to the show on Apple Podcasts, Spotify, YouTube, or your favorite podcast platform. And if you have any questions or suggestions for the show or this series on higher ed consolidation, please email podcast@ballardspar.com with your ideas or suggestions. And stay tuned for a new episode coming soon in this series. Thank you for listening.